Good afternoon, everyone. Welcome to the Stringer LLP webinar on creative sentencing for corporations convicted of offences under the Ontario Occupational Health and Safety Act. My name is Ryan Conlin, and with me is my partner, Jeremy Schwartz. And thank you for joining us to take you through what is a very interesting and sort of completely out of nowhere change, it seems, to potentially to the sentencing regime here in Ontario. For those of you who aren't familiar with us, Stringer LLP is a long-standing management-side labor and employment law firm practicing in all areas of labor and employment law. Both Jeremy and I, amongst other things, practice extensively in the area of occupational health and safety. And that's what brings us to talk about the changes that have come about rather suddenly here in the province of Ontario. At the end of the presentation, we will make sure to leave time for questions. And the process for doing so is you can type your question in the field box and just click send, and it will be added to our queue of questions, and we'll make sure that we answer them. As sometimes happens, if the field is not expanded, you may have to press the plus symbol to the left of the header, and then the questions box will come up. If you can't see the questions box at all, on your screen at the top right, you should see an orange arrow. You can just click on that, and that should allow you to ask a question. So from the outset, I have negotiated, and our firm has negotiated literally dozens and dozens and dozens of resolutions over the years to health and safety cases. And in every one of those cases, in those cases where we've been able to arrive at a joint submission or an agreement with the Crown on the amount of the fine that we're going to propose to the court, I always say to clients, as do I'm sure most practitioners in this area, that it is ultimately the judge that has the final say with respect to the penalty. So it's possible that a judge could lower or raise the fine if they determine that the fine is not in the public interest. But what I say, as a practical matter, except in perhaps the odd strange case, the fines that we negotiated are within the range of penalties that a court would impose. Though it's practically possible for a court to interfere, it is incredibly unlikely. So you're fairly certain that you're going to get a penalty that you negotiated endorsed by the court, or at least so you used to. I think now we're in a world where I can't necessarily say that's the case, and that's sort of stand-pat advice that we've been giving for decades, at least until how the sentencing regime shakes out may very well be changed.
So I mean, one of the things that we should cover before we get into the nitty-gritty of Bixman and some of the decisions that have led to it is just sort of where we are in terms of the legal regime. So first, as everyone on the call likely is aware, the Health and Safety Act sets out broad general duties for participants in the workplace, and this applies to basically every party that has something to do with employees and workers and ensuring that they are safe and everybody goes home well and comes back the next day ready to go. So the Health and Safety Act enables regulations to be passed, and that's been done. There are obviously a dozen or more, almost I think 18 or 20 regulations at this point on the Health and Safety Act, which set out the different requirements aside either in specific industries or dealing with certain topics. That goes for everything from critical injuries, defining it and what needs to be reported, to individual sectors like industrial or construction sectors, mining, for example, and then more topic-specific things like dealing with designated substances, the requirements under WMIS, role or protective structures, things like that. When you violate the Health and Safety Act, or if you're accused of violating the Health and Safety Act, the prosecution is brought under the Provincial Offences Act. So essentially, the Provincial Offences Act says if you breach a provincial piece of legislation, then you're prosecuted under the Provincial Offences Act in what's either a sort of usually a Part 3 ticket, unless it's a specified offense, it's a lower piece. So generally speaking, what we've got is a prosecution that is brought by a provincial crown for a violation of a statute that the province has put out there. And so other regulations are also prosecuted under the same Provincial Offences Act, and that's for everything from employment standards, workers' compensation, and things outside of human resources law areas, such as environmental protection. So for those of you who haven't had the pleasure of going through the process, typically you have charges which are laid. It used to be the case that they had a year to lay the charges after an offense. Now they have a year after the offense, or the facts that give rise to the potential that there was an offense come to the attention of a Ministry of Labor inspector. But in any event, everything starts with that information, the laying of the information, the laying of those charges. Next thing that happens is you go in and you get your disclosure, you find out what it is that you're charged with and what sort of the Crown has in its case. Sometimes that disclosure is voluminous, and sometimes it's a fairly thin folder because it's straightforward. At that stage, or at any stage thereafter, when you go into court, you could plead guilty or you could plead not guilty. And once that happens, that determines your path. And we're not going to go through all the steps, but essentially there's two directions you can take. One is you plead guilty, the other is you plead not guilty. You plead not guilty, which is your constitutional right, you then have a trial. And the process goes forward in that direction. If you are found not guilty, you're acquitted of all the charges, then of course there's no fine or penalty to negotiate. So that's the end of your journey, unless the Crown appeals. If there's a guilty verdict, then we loop back in, and there's going to be a question for the court as to what the sentence is going to be. Now, whether you pled guilty up front or you're found guilty at the end of following a trial, there's two possible paths forward from there. Either you and the Crown can negotiate a sentence that can be submitted to the court that you believe is fair and reasonable in circumstances, or you can litigate over the sentence in what's called a Gardner hearing. And without belaboring the point that there is always in these negotiation sections with the Crown over whether you're going to make a joint submission or not, a lot of back and forth about what you think is reasonable, and a lot of care is taken to ensure that the Crown can get that agreed joint submission sentence approved at its higher level. So your Crown prosecutor that you're dealing with, they don't make the decisions unilaterally. They have to confirm and get that approved by more senior Crowns. And so there are checks and balances in the process. And there is a negotiation that takes place. And that's important when we talk later about the case that's happened later. Very briefly, the way that the different workplace parties, we've just listed them here, but essentially every party that has any connection with the workplace and anything to do or say about whether people are safe at work and the policies and processes in place has actual liability and actual responsibility under the Health and Safety Act. Now, maximum fines recently went up. For those of you who are aware, they tripled for corporations and they quadrupled for individuals. Used to be $500,000 per count for a corporation, now it's $1.5 million. Used to be $25,000 for an individual, that's jumped up to $100,000. That was only a couple years ago. Now, convictions which relate to events that predate that increase will be subject to the old limitations on fines, but anything that relates to events that happened after the change, those charges will be laid under the new rules and will have the new limitations.
All right, so I wanted to speak, if I can, about what the sentencing principles are historically, and these come out of a decision, a well-known decision from the Ontario Court of Appeal called Cottonfelt, which, I mean, is almost 40 years old now. It's one of the true sort of chestnuts of litigation in Ontario. But basically, what the courts consider are things that are specific and general deterrence, specifically meaning just deter the specific offender before the court, and general deterrence, meaning that the other offenders, the employer community in general, are deterred. And Cottonfelt is focused on fines. It's obviously you can't imprison a corporation, so it's historically, Cottonfelt looks at how much the quantum of the fine has been, and that has been the primary method by which corporate entities have been sentenced under provincial offenses in Ontario and across this country for time immemorial. And Cottonfelt is the case that's referred to nationally. It is the gold standard for how corporations are sentenced. The amount of the fine is the things that probably aren't going to surprise you. The size of the company, larger fine in terms of specific deterrence. Scope of the economic activity at issue, which again says how profitable, how large is the company, how much was the construction project worth. These are sort of the actual and potential harm to the public. Obviously, the more severe the injury, if this is a health and safety case, the more higher the sentence. Even if there is no injury, the more higher the potential harm, i.e., a big difference between someone not being connected to fall protection, where someone could die, whereas if someone was perhaps being prosecuted for not having a document on site, which does happen from time to time. In terms of, we're not here to talk about incarceration of individuals, which has been the subject of other recent litigation, other than suffice to say that incarceration is now more easy for the Crown to obtain in provincial offensive statutes than it's been historically, thanks to a recent decision of the Court of Appeal. Probationary terms are practically unheard of. In my entire career, I have had probation imposed exactly once in a very similar circumstance to the cases we're going to talk about. It was involving an individual, and the court just came up with it herself, that this individual should, in this particular circumstance, who had been convicted of an offense in connection with a fatality, was going to be retrained as a driver, and that came as part of his probation, which was not a particularly onerous term, so it wasn't something that became controversial. But again, it was something that the Justice of the Peace came up with out of nowhere. The case was a contested sentencing argument about whether the accused should be incarcerated, and the court sort of came up with this sentence. But again, that's a highly unusual situation. And again, that one followed conviction at trial. Sentencing, ultimately, what Cottonsel's primary goal is to ensure that the sentence is not a mere license for non-compliance, and it's not treated as a cost of doing business, so to speak. So we're going to move on to the issue as to what is a joint submission. A joint submission is, as the slide indicates, an agreement between the Crown and the defendant, which is used for both individual and corporate accused, as to what the penalty, which in corporate sentencing in Ontario is the fine, ought to be. This often, as Jeremy had described, results in settlement negotiations between the Crown prosecutor and the defendant, which is sometimes assisted by a judicial officer during a pretrial conference, who's entitled to weigh in on a without prejudice basis as to his or her thoughts on what the penalty ought to be, and that often guides the parties. But the reality is that a joint submission has been recognized by the highest courts, including the Supreme Court, particularly in a very, very famous report known as the G. Arthur Martin Report, which encouraged the use of joint submissions as a way of resolving cases. Otherwise, of course, if every case went to trial rather than being resolved, the taxpayers of Ontario would be sending most of our money for hundreds more judges just to hear these cases. And so obviously the courts are anticipating that there is that people are less likely to plead guilty if they think that that they're not getting any reasonable degree of certainty as to what the fine should be. However, Martin and the courts have recognized is that the court has a gatekeeper function. That in some circumstances, a penalty just seems so out of whack with what the court is used to imposing in similarly situated circumstances that it's contrary to the sentence being proposed by the Crown and defense is contrary to the public interest and would bring the administration of justice into disrepute. And for the purposes of clarity, that could be because the consensus is either too severe, or the fine is too high in a corporate case, or the court thinks the fine is too low. It can flow both ways. It's not always that the fine is going to be increased. And this is just a quote from the Supreme Court that, it shows you what the standard is, though, in very, very plain language for the Supreme Court. It's often, usually writing in flowery legal language, but it basically says, it denotes a position taken. It's so unhinged from the circumstances of the offense and the offender that acceptance would lead reasonable and informed persons, that the proper functioning of the justice system has broken down. Well, if you look at that kind of language, that's a signal from the Supreme Court just 4 years ago in the Anthony Cook criminal case, which applies equally in these circumstances, that unless the penalty is so crazy, you just try to think of this by analogy, that if you walked into a car dealership and someone said, you can buy this new Mercedes for $10,000, that of course makes no sense, right? A Mercedes is $80,000. So, it's the court's meant to say that unless what's been agreed to, it's so ridiculous. And in light of the safeguards that are in place in the Provincial Crown's office and with well-informed defense counsel, that should not happen very often. It's the job of the Crown just to be sort of a judicial officer, a minister of justice, to ensure, that a particular offense, the offense is appropriate, submission is appropriate. So Anthony Cook recognizes these circumstances shouldn't arise often. It should be in the clearest of cases that a joint submission is rejected. The joint submission is made after the defendant is found or pleads guilty to one or more charges. The bottom line is what people need to understand, you can't necessarily withdraw your guilty plea if the court doesn't accept the position on fine. However, the Supreme Court has said the court has discretion to decide whether to actually withdraw a plea, which that shows you just how infrequently it is that a joint submission will be interfered with. If a court is willing to allow someone to withdraw an admission on the record that they did what they were accused of. So it raises some interesting questions. So that's the legal framework. Let's see how it applies in this exceptional as it's applied in Ontario. The first case I want to talk about is the recent decision of Ministry of Labour versus Lafarge, and this is a guilty plea by way of the defendant. It was a tragic circumstance. The worker fell to his death when a catwalk regularly used by workers to traverse between active areas collapsed. So we are talking a significant hazard that could have had a potential for more harm if more people were on it. Obviously, it is the catwalk had been decommissioned and was known to be out of bounds, and no barriers prevented access. So, I mean, again, it wasn't. It was a situation where obviously the risk of fatality was high, and the measures taken to prevent it were clearly legally insufficient. So it's not surprising that the defendant pleaded guilty on these facts. It sounds on the basis of the facts described by the court, there is no conceivable defense. The joint submission was $400,000, and that is was close to the maximum fine permitted by the court by the legislation at the time of the incident. So it's 80% of the maximum fine of $500,000. And also remembering that $400,000 is subject to a 25% victim fine surcharge. So with the surcharge, and dollar for dollar, the accused is basically paying what the maximum fine was. However, when this joint submission was presented to the court, Lafarge's prior record of convictions under the Act, which is obviously when an accused has a prior conviction, that's what's called an aggravating factor, or something that tends to increase the fine. And Lafarge had 3 prior convictions for fatalities, and 1 prior conviction for a lockout-tagout offense, where a worker suffered serious burns. And the total fine in those circumstances was $765,000. And the Justice of the Peace was just incensed that it just seems that despite this prior record, they seem to have learned nothing, and were, in his submission anyway, that the penalties weren't enough. So the court considered rejecting the joint submission, which would have been an extraordinary measure, and implementing something called an embedded auditor at the company's expense as part of the probation order. I can certainly tell you that based on my experience that this particular Justice of the Peace has been discussing this concept on a without prejudice basis in various matters, without getting into them specifically. It is something that he has, I'm not sure the word is a hobby horse, but certainly something that he believes would be an appropriate sentencing measure in certain cases. And the concept of an embedded auditor is really a private party being paid for by the company that would go in and as part of a probation order, enforce safety compliance related issues, audit and make recommendations. I think quite correctly that the court determined that the joint submission was not sufficiently unhinged as required by the Supreme Court and Anthony Cook. In my opinion, I would go further than the Justice of the Peace. It was not even close to being a circumstance where it would be appropriate for a court to interfere with the joint submission. The reality is it's to the legislature to impose what the maximum fine is. The company was very close to what the maximum fine, which for worst case, worst offender. And while I agree that certainly having the prior convictions that Lafarge did does lean it very close to the maximum fine, it's certainly not a situation that is unhinged to give them 80% of the maximum fine. It's just not. It's not even close. And embedded auditors, well, certainly maybe a concept that is an effective sentencing mechanism. It is just not something that's ever been done and is not specifically contemplated by the legislature in terms of dealing with a corporate probation order. It's just, it was almost developing judge-made law as opposed to statute. And it certainly isn't, and certainly, in my view, would not have been appropriate for the court to interfere with the joint submission. But I will say, closing my comments on that case, that the judge made it clear that future corporations with a record like that come before him might be looking at a different kind of sentence.
Okay, so now we fast forward a year, and you've got Vixman Construction, which is what was the impetus for our webinar today. And in this case, the court went all the way. So as opposed to musing about and articulating in great detail what the court thought would have been a better result than the joint submission proposed by the Crown and Defense, in this case, the court found that the Anthony Cook test, that very high threshold was met, and as a result, it was open to the court, in the court's view, to reject the joint submission and to impose its own penalty. So let's start briefly with the facts here. We have a worker who tragically fell to his death working at the Toronto Island Airport. Keeping it very simple here, there was a lifeline which was incorrectly installed, and there was a process which involved doing such things as taking certain measurements and doing certain calculations, which no one had taken any steps to ensure the workers did. And they didn't do those things, and so as a result, this worker passed away. So obviously very serious consequence for this violation. The corporation was convicted following a trial, so they did not plead guilty, unlike in Lafarge. And here the Crown and defendant made joint submissions after negotiation, presumably, and that joint submission was for a $125,000 fine. This was the first conviction for this defendant of a fatality. And of course, the victim fine surcharge, 25% was applied to that. Now, the court expressed, while the submissions were going on at the sentencing stage, so of course there's the end of the trial, the sentence is read in, the accused is found guilty, that's done. Now the submissions are being made on sentence, typically on a different day. And during those submissions, but before the court decides whether or not to approve that joint submission, the court expressed on the record that there were serious reservations about whether this was an appropriate thing to do and whether or not creative probationary order would actually be more appropriate. And apparently, and this is part of the judgment, the court noted that the accused was apparently willing to discuss those things. Of course, that willingness came only after the court expressed the serious reservations about whether or not to accept the joint submission. And so I'm not sure we need to take that willingness with a grain of salt. Ultimately, the court rejects the joint submission, which means the court found that the $125,000 fine was unhinged. By definition, that's what the court must have found. And although it imposed that same fine, it added a probationary order with numerous terms, things that had not been discussed by either the defense or by the Crown, and things that we were not aware of any other previous case, including these in the probationary order. And these included requirements for the employer to write to the IAPA, which is, of course, the health and safety body, that sort of pseudo-government, which throughout the province provides training and publications and what other things. IHSA actually was the organization. My apologies. Thank you, Ryan. And the order was for them to write to the IHSA to have them publish in their publication an article about the lessons learned from this incident, dedicate that article to the deceased worker, but also to produce at their own expense a safety training video, which would also be dedicated to the memory of the worker and which would be available publicly. So we're not aware of this ever being done in the history of basically Canada. Ontario for sure. I'm actually not aware. Are there? Yes. Oh, Ryan apparently is aware of some of these going on outside under different regimes. We'll talk about that in a moment. Notably, parties did not submit a lengthy agreed statement of fact. So it's typical in a joint submission for the parties to put together a joint agreed statement of fact, which sets out not just the minimum criteria to find the defendant guilty of the charge, but also some of the other facts about mitigation, about aggravating factors, about the size and scope of the company's activities, all of those factors that Ryan mentioned, which go into that analysis under Cottonfels. Typically, those are the sorts of things you want to provide the court so that the judge can satisfy him or herself that the joint submission is not unhinged from the company and the circumstances. Now, if you have a look at the decision, you'll see that there's 4 or 5 bullet points which say almost nothing, and then there's a joint submission on sentence. And the parties did not submit, although the Crown did submit a brief of a few cases that it submitted were comparable. The judge noted that the cases were 3/4 of the 4 cases, there are only 4, were more than 10 years old, and that in his view, these did not provide him with a representative sample that he could draw on to say, yes, similar cases decided similarly, this is therefore a reasonable joint submission. Now, the court distinguished, and this is quite important, joint submissions following trial and conviction, and joint submissions at the early stage on a guilty plea. Now, just for those of you who don't have to do this every day, the way the court is supposed to treat an early plea is as a mitigating factor. So what the court is supposed to do is say to themselves on an early plea, what would I have done if the judicial and state resources had been used? What would be the right sentence in this circumstance? And then reduce that because of the mitigating factor of an early plea. But in our view, on reading the decision, it would appear the court has turned that on its head and essentially penalized the defendant for utilizing their constitutionally protected right to plead not guilty and to have a trial. Now, we all understand why a mitigating factor is there. I mean, conserving judicial resources and taxpayer money, that's all in the public interest, but that can't subvert the right of the accused to plead not guilty and to force the Crown to prove beyond a reasonable doubt their guilt.
But yeah, thanks. I mean, it is an interesting situation when you get a circumstance like that. I will say there is some judicial support for the concept that the value of a joint submission is somewhat diminished where an accused has been convicted after a trial. However, I mean, in my view, that's a fairly, not a lot of cases that comment on it. And in my view, that there's often, even after a conviction at trial, there's still often quite a few resources that can go into a plea negotiation. Because remember, the factors that are relevant in sentence aren't relevant at trial. Like Jeremy talked about an agreed statement of facts even after a trial. Well, the reason that might be is because you're not necessarily talking about the size and scope of the corporation. During the trial, you may or may not be talking about events that postdated the offense that would be relevant on sentence. You certainly may not talk about dramatic changes in facts. Perhaps the company was very profitable at the time of the charges and not 3 years later, after about a year and a half later, under the Jordan regime, after a case goes to trial and is sentenced, and all those things would never come out of the trial and would come out potentially at a sentencing hearing. And further, there is the possibility, in what's known as a Gardner hearing, is for the Crown to call aggravating factors on sentence, things that aren't relevant to the offense, that of proving the offense, but may in fact be an aggravating factor on sentence, and they still have a reasonable doubt situation. I have certainly been involved in Gardner hearings that at least took close to as long as the trial sometimes. So so to say that there's not, I disagree with the court to say that there's no value in a joint submission after a trial. So just, in my experience, that just isn't the case. All right, so what is done outside of Ontario? Obviously, most of the Canadian economy is provincially regulated. We have 10 provinces, all of which have their own occupational health and safety regime, along with the federal regime under the Canada Labour Code for those employers that are federally regulated. Most provinces proceed by way of a prosecution system like Ontario. Some of them, British Columbia in particular, tend to deal with most of these matters through an administrative proceeding governed by the Workers' Compensation Board that really doesn't bear any resemblance to a judicial proceeding. So their experience isn't as relevant. But let's take a look at what happens outside the province. And there are some places that have moved beyond just as these courts have signaled to just dealing with the fine for a corporation in health and safety cases. Nova Scotia is a jurisdiction that actually imposes and has had some experience imposing penalties that are similar to some of the things that were contemplated by the courts in the prior James. They can order that the conviction be publicized by the accused. Note that this is distinct from the practice, at least in Ontario, of the Ministry of Labour publicizing convictions on its own website, issuing a one-page press release that typically confirms the amount of the fine, the fact that's found by the court, name of the prosecutor, where the events took place, and how much the fine was. But this goes beyond that. A court, like as we can see, as was done in Dixman, that they were going to put it into an industry trade publication. Well, it's not a trade publication in this instance, an industry safety publication that has sort of a government funding aspect of it. But it could be anything. You could have them say, take out a full-page ad in the Globe and Mail, announcing the details of it. That's not what's happened in Nova Scotia, but it certainly could. There's performing community service, which in corporate context has more been in terms of educating workers on health and safety. There is the provision to pay the regulator a specific amount to fund OHS initiatives. Typically, the fines, contrary to what some people think, the fines that are imposed by the courts do not go to the Ministry of Labour directly. They're paid to the municipalities. They do not go to fund OHS initiatives. The victim fine surcharge does not go directly to the victim of the accident. All of those things, which on their face make little sense, but that's how it goes. There's been orders to make safety presentations in public forums, creating memorial funds for deceased workers, paying for advertising, again, just in general that promotes worker safety. So Nova Scotia is a jurisdiction that has, depending on your perspective on how you believe things should be sentenced, has certainly given courts more options than just the historic corporate norm of imposing a fine. Alberta, again, is similar to Nova Scotia, not quite as broad, but certainly they have probationary terms that include enhanced regulatory scrutiny. And if you look at the criminal code as far as it relates to sentencing organizations, these were the amendments that came into force in 2004 for the Bill C-45 amendments. But you look, the federal criminal code also has broad probation terms that imposes a fair potential degree of regulatory scrutiny ongoing. I can certainly say that Jeremy and I have been at least involved in one federal food safety prosecution where there was a very extensive probation order, notwithstanding that the regulator had extensive regulatory inspection powers of what type of reports would be done and issued to the Crown. It was pages and pages of a probation order in the context of a regulatory prosecution. So it's been done in the federal sector, certainly in Alberta. The most common penalty is making charitable donations to a relevant cause, training and education materials. And I should note, and this is an important question, that when creative sentencing is involved, at least in Alberta, it is taken into account when the fine is assessed. It's not always been an additional penalty on top of the fine. What the court has been doing is, okay, instead of this fine, maybe in some ways the charitable donation is almost essentially redirecting the penalty to a private entity potentially, as opposed to sending it to the provincial crown. So, I mean, again, it's an interesting. It's interesting, and there's certainly precedent that if Ontario moved towards this direction, that we would have the potential for sentencing in this area to be imposed like that.
So one of the things sometimes we get asked, we say often, but I guess it sort of depends. We do get a number of clients that say, well, what about this ability to have the charges withdrawn, or to have the penalty simply be that we make a donation to a relevant cause, or we do some of these things ourselves in a creative way.
Yeah,
client initiated.
Yeah, well, I mean, and the thing is, Jeremy, I mean, we sort of, because it's not something we're used to in the context, in this kind of context, but in certain types of prosecutions, particularly dealing with Security Act prosecutions, particularly in the United States, civil settlement is not, it's not an uncommon thing.
No, not at all.
That rather than going through the criminal process, that some other penalty is imposed by the OSC or by the FEC in the U.S. as opposed to going through the actual proceeding in court. So, I mean, when we're often being asked by general counsel who are been exposed to these type of issues and other kinds of litigation. So it's not a totally off-the-wall question. It's just in occupational health and safety in Ontario and in general in Canada, this is just not a thing.
Right. Now, part of the reason it's not a thing in Ontario under provincial regulatory regimes, in particular under our Provincial Offences Act, it's simply prohibited. So this is not something that our Provincial Offences Act provides us the ability to do, a tit-for-tat exchange. But if we all think back to the SNC-Lavalin controversy, which might still be present in some of our minds, the issue in that circumstance was about remediation agreements. Now, the criminal code allows for these expressly, and very recently, and that's the very reason, of course, that was one of the issues was, SNC, I suppose, wanted access to a regime that they had lobbied to create, but then they found to their dismay that apparently it wasn't applicable to their fact pattern. But in any event, the key...
At least you're the Attorney General.
Sure, but the key that we have here, of course, is that the way that they work is that the charges can be withdrawn at the discretion of the Crown and the Attorney General's office. The charges can be withdrawn in favor of what is similar to probation orders. So remediation agreements can include everything from orders to have certain processes in place, certain audits in place, certain payments and penalties to be imposed otherwise. Now, again, that's not possible here in Ontario under our Provincial Offences Act, but this is the sort of thing that if the government, not necessarily the courts, but if the government saw was something to be explored, that might be the sort of thing that we might see coming into the future. And we'll talk a little bit about that as we talk about sort of what we see as the evolution, potentially, of the way that these mechanisms are used. But as Ryan said, these are fairly common, in particular, in health and safety in the U.S., where civil settlements are actually a primary enforcement mechanism, just like where you have large-scale bank fraud issues and things like that, where they'll actually negotiate a large fine for the organization, and none of the directors or officers go to jail. So where do we go from here, Ryan? What do you think?
Look, I think that the one thing, I think the most important thing for us to consider is joint submissions are going to be could be subject to greater scrutiny from the courts in occupational health and safety matters. I think there might very well be, and understandably, given the history of these matters, a certain degree of complacency that has taken place amongst the bar, both on the prosecution and defense side, that, you know, if the learned counsel, learned in quotes, I suppose, agree to a particular penalty, it's going to simply be rubber stamped by a court. And I don't want to overstate this. There are literally hundreds of Ontario occupational health and safety prosecutions, ranging from as simple as a set fine to a situation where you're dealing with a fatality. And in the overwhelming majority of cases where there's a plea of guilty and not a set fine, the court endorses the joint submission, whether it's worked out with the accused directly or with their counsel. So I don't want to over-exaggerate the fact that we do have, these are two decisions out of hundreds. That being said, they are reasoned in incredible detail. They are going to get the attention of the OHS prosecution and defense bar. They will get attention perhaps beyond health and safety. For those of you who may be litigating other corporate matters where fines are the primary enforcement mechanism, it may very well be that this type of, shall we say, judicial concern about fines as the primary mechanism of enforcement may spread to other things. But I do want to be a caution. These are two trial level decisions.
One guy's not following here.
So this guy's not following, and we haven't had an appellate court weigh in. And I don't think we are going to have. No, there's nothing to appeal in Lafarge. He accepted the joint submission. And in Dixman, really, in the end of the day, I don't know, but I don't imagine that that's likely to be appealed. So it may be a case for another day for an appellate court. Ultimately, the Ontario Court of Appeal, by leave at the end of the day, that's going to comment on these issues and deal with joint submissions. I think it's inevitable within the next couple of years that at least the province has for it. It's going to deal with that issue.
Okay, so I mean, realistically, from a practical perspective, right? We as practitioners and our clients and those advising from within need to be aware that when you're facing one of these prosecutions, your negotiations with the Crown, that sort of friendly chat in the morning that Ryan and I would give you when we're negotiating with the Crown, either before a plea of guilt is entered, or when we're approaching the end of a trial and we think that a conviction is likely, or once a conviction is entered, and we're negotiating to have a joint submission on a fine. The usual, well, we're going to enter into a negotiation, although the court has to stamp this with approval. In our experience, it had never happened before. We're going to have to water that down a little bit. We're going to have to be giving all of our clients a little bit of salt to wash that down with. And ultimately, there is now, at least in our view, a greater risk that the parties, any parties that come to court without all T's crossed and I's dotted, to show the court, well, to number one, show the court that the joint submission is reasonable and within a range, but also to give the court pause and ammunition that it can see coming if it were to find that the Anthony Cook threshold of unhinged is what the court wants to find here. It's much harder to do that if the parties have done their homework and provided enough information. So I think the parties really do have to be, more than ever, we always have had that obligation, but now more than ever, in a position to show the court that the joint submission penalty is consistent with recent court authority in similar cases. The court has to be provided with the information it needs to be comfortable that this is not an unhinged decision, or at least that it would be subject to a very likely appeal should it reject the joint submission, finding that the submission was unhinged. In some cases, it might be helpful to involve a pretrial justice in that joint submission. So typically that would happen before a trial and a conviction. I'm not aware, Ryan, I'm not sure if you are, of sort of a post-trial mediation with a justice being involved, although I suppose there's no rule expressly
Never heard of
it. Not in our experience, though. But certainly, if you're going to be entering an early plea, that's the time to get the justice who will be entering and approving your plea involved in that negotiation process, so that ultimately they're more likely to approve.
Yeah, if I could just jump in and explain that a little more. Basically, what that basically means, every case, but even ones that are almost every case, unless it's a very early plea, has a pretrial conference, as it's known, and that's whoever the justice of the peace is who's assigned to it. And ordinarily, if the matter proceeds to trial, the pretrial justice doesn't hear the trial, because to allow the parties to make without prejudice comments. But if the parties are able to come to a joint submission, a justice of the peace can then seize him or herself to then hear the plea, and then ultimately, as a practical matter, a JP in a without prejudice comment is going to tell you if they think this penalty is unhinged, and this is completely unreasonable. This is something I would never approve. So I mean, but you may also end up in a circumstance where the justice of the peace trial might not be the one you want entering the plea. So that's a tactical decision for counsel to make, I guess. All right. So we expect, obviously, at the end of the day, as we said, that appellate courts will eventually weigh in on this subject. But I mean, again, the wheels of justice grind slowly to get to the highest court. For example, we'll be arguing a case at the Court of Appeal next month that was tried back in the summer and was tried in the winter of 2018 and is now will wind its way to the Court of Appeal from the date of judgment almost 2 years later. So I mean, it takes a while for these cases to get up to the Court of Appeal. So it's going to be a while before we have some judicial guidance on this issue. It's our view that it's probably time for the government to engage in some stakeholder feedback on this issue. I think there's a very legitimate point that just because this is the way we've done things for 40 years across Canada, that there becomes this sort of inertia that takes place, that this is the way it has to be done. And we know from Nova Scotia and Alberta and foreign jurisdictions that that's not necessarily the case. There may very well be some value in certain circumstances of probation orders, but there is no value in it, in my view, without the cooperation of the regulator. I mean, unless you're going to endorse the concept of an embedded auditor, that not having the Ministry of Labour in favor and having their crowns dealing with probation orders, it's not, in my view, particularly helpful to have suggestions of probation orders coming from the bench without the cooperation of the regulator. And of course, then ultimately the government's probation arm, who's actually involved in supervising these things, right? It's like a probation order, a breach of probation is an offense, and someone's got to be set up and in a place, and I think a probation officer who came in with a health and safety situation might be in for a bit of a surprise, never having dealt with such a matter probably in their entire career. And I think if such a discussion ever took place, we can look at a big picture of enforcement mechanisms, whether the embedded auditor concept, the private embedded auditor concept makes sense, and perhaps having a statutory guidance for how such a process works, and who such an auditor is, and how they're qualified, and what their powers are, and who they report to, and all those kinds of things that don't currently exist. Administrative monetary penalties. Certainly there are some regimes out there that have sentenced employers on an administrative basis, like British Columbia. Those kinds of, I mean, there's advantages and disadvantages to those things. The advantage are that it's not a quasi-criminal situation, but the disadvantage is they're sometimes more difficult to defend. You don't have a due diligence defense, and in typical AMP regime, you did it or you didn't, or you didn't. You did it or you didn't, and maybe your due diligence is a mitigating factor in how much the penalty is. But so there's advantages and disadvantages. Charitable donations. I mean, there may very well be some real meaning to allowing charitable donations from corporations, so that the money just doesn't go into the general revenues of whatever level of government you're dealing with, and actually goes to an organization that could offer benefit to worker safety. I mean, again, one has to be cautious about such situations. And there's one instance in Manitoba where a Crown prosecutor approved the donation to an organization that he actually had a personal connection to. So there is circumstances where that probably requires some judicial supervision. There's also the thing that almost never seems to come up in occupational health and safety sentencing is workers' compensation surcharges. I mean, employers, especially larger employers, will pay significant amounts of workers' compensation surcharges in the case of a severe injury, and there also there's policies around taking away certain advantages for for fatalities. In fact, workers' comp under the new regime has a very specific provision in Ontario for making sure a very specific charge, one that actually exceeds the potential cost of a fatality, because, of course, from an insurance perspective, it's sadly cheaper. Those things are lower than a serious injury claim because of the lack of ongoing medical treatment to a deceased. So whether that's a factor in that should be considered to raise or lower a penalty. The other position is absolute and conditional discharges. We know from the world of criminal law, under the criminal code, that accused that are convicted of various offenses can have their record expunged, either absolutely, because the court believes it's a lower range, or conditionally, subject to, typically as an individual accused, that's keeping the keys and being of good behavior, complying with your probation orders, not being before the court again for anything else. And maybe that might be, particularly for first-time offenders in the OHS context, maybe something worth considering as an option. Thinking outside the box a little bit would be, I think, is an excellent idea, and I'm in agreement with the justices that perhaps the current regime of sentencing that we have is perhaps too rigid. And certainly when we look at the criminal code in other jurisdictions that have broader options, those things should be considered. But I think they need to be considered at the level with the government, with the cooperation with the regulator, with safeguards in place to make it clear what the options are and are not, and how they function. And if we're going to have probation as part of the regime, to have a probation system that's equipped to deal with it, which I am frankly not.
There's lots of money for that, Ryan, these days.
Yeah, well, sure. There's all those things. I mean, I know I'm obviously waxing a little poetic here, but in the end, it's our message is that we're in a bit of a state of uncertainty as to where sentencing is going in the province of Ontario, but it is our view that it will work itself out. And I think that the kind of cases like this, it's the kind of cases like this that are very that are going to be relatively rare, and it will continue to be the norm that joint submissions are endorsed. And really, I think a change to sentencing is going to have to come from government as opposed to from the bench.
So we're opened up the question panel, which we couldn't see during the presentation. So our apologies to any of you who had difficulty. I understand you could hear what we were saying, but that there was sort of an echo. We're in our larger boardroom today because the smaller one was being used, and it does, I suppose, echo a little bit through the acoustics. So our apologies. Hopefully you all were able to follow through with relative ease, and we will be sending out to everyone who was registered a copy of the slides so that you can have those and review them at your leisure. I don't see any actual questions that are specific to the presentation. So we'll give you a couple of minutes. If you do have any questions, please send those through using the software. And if not, then we'll come to an early break.
Well, just one last thing I do want to indicate. It seems to be webinar week here at Stringer LLP. On Friday, we are addressing the very recent decision by the Ontario Labour Relations Board in Foodora. For those of you not familiar with it, Foodora is a food delivery company, a web-based kind of Uber Eats kind of situation, which had faced an application from a union for certification. Their defense to that application is, well, we don't have any employees. These individuals are independent contractors. It's the kind of this kind of litigation has been ongoing across North America and frankly across the world as a result of the gig economy that has risen. So the Ontario Labour Relations Board has ruled in favor of the union in this case, that these individuals are employees, not independent contractors. Whether they are actually unionized or not remains to be seen, but it certainly, the unions have overcome a significant threshold, at least on the facts, as set out in Foodora, to be able to significantly expand and bring unionization to the so-called gig economy. So if you're interested in that, please join us on Friday. Jeremy and I will have some thoughts on that, both in the context of what it means for labor relations, but also beyond in human resources in terms of workers' compensation, immigration, human rights, and all those other factors as to how this will impact the so-called new or gig economy.
Still not seeing any questions, so I think at this point we'll call it a day. Thanks very much for joining us today. We hope you found it informative, and we'd like to thank you again for keeping your eyes on our website for all of our updates and future programs. We really do enjoy all the feedback that we get. We will send out a feedback request form. If you do have the time, we would greatly appreciate the feedback. Obviously, we take it that there were some audio issues here, but other constructive feedback would also be appreciated. Okay, so thanks very much. Have a great day, everybody.